Hello and welcome to this session in which we will discuss the concept of suretyship and guarantor. Now, why do we need to have suretyship and guarantor? What's the purpose? What's the business purpose of this concept? Imagine if you want to get a loan from the bank, and at some point I was a loan officer myself. So when person A walks into the bank to get a loan, first they have to show their income. They have to show how much assets they have, because the bank is concerned that if we give money to this individual, there is a risk that this individual A may not pay the bank. So what would the bank tell this individual if they don't qualify? Well, if you don't qualify, we used to tell this individual, can you get a co-signer? Can you get someone to sign the loan with you? If you can get someone to sign the loan with you, then you might qualify for the loan. So if A goes to B and asks B to co-sign the loan, which is to guarantee the loan, well, the bank, if A has income, has assets, and they have, obviously, I mentioned, good credit. Sometimes A may not have no credit because they might be young. But if B has a good credit and income, then what we do, we would say, okay, now you qualify for the loan, but here's what B has to know. If you don't pay off the loan, if you don't pay us, B is responsible for that loan. And this is the concept of suretyship and guarantor. Now, there's a difference between the two, and this is what we will discuss in this session. What's the difference between a suretyship and a guarantor? But think of it as someone who's co-signing the loan, helping someone get a loan. Now, why would B, let's talk about this a little bit further. Why would B wants to guarantee the loan of A? Well, it could be a family relationship. Grandpa, grandma. I remember many grandmas used to co-sign the loan for their grandkids. I closed several loans like this. Or maybe one business, they want to see the other business succeed because they're part of their supplier network. Or they want to do them a favor, therefore they can get, preference treatment somehow. They will guarantee the loan. So this is when that happens. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
So suretyship and guarantor are needed primarily to manage financial risk and enhance creditworthiness. Simply put, the bank doesn't want to take any risk with this individual. They will ask them to do what? Bring another individual, another party, another company, another legal entity to sign the loan. And the whole purpose is to provide the lenders, which is the bank, with added security that a loan will be repaid, especially when dealing with borrowers who have a limited credit history, like young people. They don't have credit history, or lower credit worthiness. Over the years, they don't have good credit, maybe a business, maybe an individual. Therefore, they need someone to do what? To guarantee the loan for them. And this arrangement is crucial in business transaction, especially in large contract. Simply put, it doesn't go through unless you have a co-signer. And this helps in complying with legal and regulatory requirement, because if individual A don't qualify, well, you cannot give them the loan. To comply with the legal requirement, they have to bring someone, and this way the loan will fly. It's also beneficial for the business, for the person and the business that's getting the loan, because they're building their credit history. And this way they can secure loans, a personal or an international trade. They can get loans to conduct business and have financial stability. Suretyship and guarantor. So we have to understand there are two terms that we need to be familiar with when it comes to those, in quote, co-signing. The suretyship and the guarantor, obviously you already know, it involves three parties. The creditor, think of the creditor, the bank, the company that's given the money, the debtor, the person, that's person A, we're going to call this person A, the person that's trying to do what? Trying to obtain the money, and either a surety or a guarantor, which is we're going to call them party B. So this person is trying to get trying to help someone else. So we have the creditor, one, the debtor 2, and the surety 3. So the surety is helping the debtor get a loan from the creditor. I hope this makes sense. So let's talk a little bit more about the surety. We need to understand the difference between a surety and a guarantor. A surety is someone who agrees to fulfill the debt or obligation of the debtor directly to the creditor. So the key concept here is that the surety is immediately responsible for the debt if the principal debtor don't pay. This means the creditor can go directly, and I'm going to emphasize this point several times in this lecture. They can go directly and demand the payment from the surety without having to seek payment from the debtor. So they can go directly to the cosigner, tell the cosigner, pay me. Example, David borrows $15,000 from Emily. So Emily here is the creditor, David is the debtor, with the repayment deadline on July 1st. Frank acts as surety for this loan. Simply put, David needs someone to help them. Frank is willing to do that. On July 1st, when the loan is due, David don't pay the loan because they don't have money to pay, fails to repay. Emily will go directly to Frank and say, look, you co-signed this loan, pay me. Frank is liable for the debt, irrespective whether Emily tried to collect the money from David first. So Emily can go directly to Frank and ask them for payment. It doesn't even have to go to David. Whether David pays or not, that's not Emily's problem. Let's take a look at what a guarantor is. A guarantor, they have a responsibility, but that responsibility is conditional upon the debtor's default. What does that mean? It means the guarantor promised to pay the debtors only if the debtors fail to do so. So we're going to look at the example of David, Emily, and Frank shortly. But simply put, you can't go to the guarantor directly. First, you have to go over the person that borrowed the money. The creditor must first attempt to collect the debt from the principal debtor, the person that borrowed the money, before they can demand the payment from the guarantor. So if we go back to David that borrows $15,000 from Emily with the same repayment deadline, this time Frank guarantees the loan. Here, if David doesn't pay by July 1st, Emily must first exhaust all effort to collect the money from David before she can go and ask Frank for anything. So Frank's obligation to pay only arises if David defaults and Emily is unable to collect the debt from David after reasonable attempt. So notice there's a big difference between guarantor and suretyship. Suretyship, you're more at risk because you have to pay as if you borrowed the money yourself. There's also something called guarantor of collectibility. This is a special type of guarantor. And basically, this person is only liable if the creditor cannot collect the debt after all legal method, like demanding the money, lawsuit, judgment, and all legal proceeding has been exhausted. So they have more time. This adds extra layer of security for the guarantor. Notice it's for the guarantor as their liability only triggered. So the responsibility is only triggered after extensive effort to recover the debt from the debtor. So surety is the worst. Guarantor next, guarantor of collectibility is third, so they have more time. Any surety relationship must be in writing. You have to know this, and we learned this about this when we learn about the statutes of fraud require that any promise from a suretyship to be in writing. This rule prevents misunderstanding and fraudulent claims because this is a serious consideration. You're guaranteeing the debt of someone. Well, you need a signed agreement. Now we have to understand, I'm going to repeat this more than once today, the creditor. The person that lends the money, they have a lot of options. They have the flexibility to demand the money from the surety immediately. They can demand the money from the debtor, or they can go after the collateral. What's the collateral? It's when the debtor borrows the money, they may put up some asset as a collateral, like a home, a warehouse, inventory, whatever they put as an asset. The creditor can go after the asset as well. So the surety cannot say, well, wait, I'm not going to pay, ask the debtor first. They can't do that. The surety cannot dictate which of these steps the creditor should take first. However, a guarantee of collectibility, remember, has the right to insist that the creditor attempts all options to collect from debtor or seize any collateral before asking them to pay. So what happened after the default occur? After the default, generally speaking, the surety does not have the right to receive a notice. So simply put, they say, okay, the person that you guaranteed the debt for cannot pay it. You are required to make the payment. So the creditor required them to make the payment. The surety, again, cannot insist that the creditor use any held security to offset the debt. Who can do that? The guarantor of collectibility. They can do that. This means the surety may be immediately responsible for the debt, not maybe, will be immediately responsible about the debt without prior warning or effort made by the creditor to collect the money from the principal. So you have to be very careful when you co-sign a loan and there's a surety issue here. What rights does the surety have against the debtor? Well, they have few rights. We're going to look at them. They don't have any rights against the creditor. Let's see what the surety can do. Well, when a principal debtor fails to pay their bill, well, the surety has guaranteed the debt and may initiate a legal action known as exoneration. So what is exoneration? This is one of the rights that they have. This is a request made to the court to compel the debtor to pay the debt. Immediately you go to the court, you tell the court, please ask this person who I guaranteed the debt for to pay the debt, relieving the surety from their obligation. So for example, if A, the debtor, fails to repay the loan to B, the B is the bank, and C is the surety, C can file a suit of exoneration to force A to pay B directly. To do what? To avoid paying the debt yourself. You can try to do that. Remember, the creditor can come after you directly. Then, after the surety pays, if this did not work, and oftentimes it's not going to work because you are responsible to pay, what can the surety do? The surety becomes the creditor. Simply put, the surety, they acquire the right of the creditor. They step into the shoes of the creditor because they paid off the loan. Now the debtor, they're going to tell the debtor, you owe me the money. This means the surety can enforce any rights the creditor had against the principal debtor, including claiming any security interest. So if they have any collateral, a home, inventory, warehouse, office building, they can take it. And they can exercise any priority in bankruptcy proceeding because they become a creditor. So if we go back to the example, so if C pays the loan, C was the surety and pays the loan to bank B on behalf of A is out. B is out because we paid off B. Now C will go after A. C can exercise the right that B had against A. Basically, C becomes the creditor. C becomes the bank of A, such as claiming collateral that A provided to B. Also, there's an indemnification. Once the surety pays the creditor, they are entitled to get paid by the debtor. As we said, they fill in the shoes of the creditor. The right of reimbursement known as indemnification. You have to pay them back. It differs from exoneration, where the surety aims to avoid paying. So exoneration says, you know what, just can you keep me out of this? They'll ask the courts to keep them out of this to force the debtor to pay. If exoneration does not work, then you have to go to reimbursement. Then you say, okay, I'm going to pay and I'm going to force the debtor to pay me back. So if person C ends up paying the loan to the bank, C can sue company A for reimbursement of the amount paid. So just to summarize it, so once the surety pays off the debt of the debtor, they can go after the debtor, asking them to pay them back. Which is it's fair. If I guaranteed your debt, I did you a favor for one reason or another. You can't pay off your debt. I have to pay it. I'm gonna come after you. Let's take a look at this multiple choice questions from farhatlectures.com. And basically the question is simple. What is exoneration in the context of surety? What is exoneration? It's a definition you need to know. It's basically asking the court to do what? To ask the debtor, the person that borrowed the money and you guaranteed the debt for, to pay off their debt. Okay? Is it A, the process where the surety takes over the debtor's company? No, the surety don't take over the debtor's company. The surety is securing that debt, saying if they don't pay, I will pay, but that's not exoneration. It's the legal action a surety initiate to compel the debtor to pay the creditors directly. Yes, That's what exoneration is. So if exoneration does not work and the surety end up paying, they have another right. The right of what? The right of reimbursement. The method, so B looks like a good answer, but let's look at C and D. The method of transferring the debt from the debtor to the surety. That's exactly what happened. The debt goes from the debtor to the surety, but that's not exoneration. Exoneration trying not to let that happen. So C is out. The cancellation of the surety's obligation after the debtor pays off the debt. After the debtor pays off the debt, automatically the surety is off the hook, because if the debt is paid, they don't have to worry about anything. It's not D. Make sure you know the definition of exoneration. So this is the definition. What should you do now? You want to go to Farhat Lectures, look at additional MCQs. That's going to help you prepare for the CPA exam, do better in your business law classes, invest in yourself. The CPA exam is worth it. Take your time. Farhat here to help. Study hard and stay safe.